Hello, Audrey. Good to see you again.
Hello, Emma. It's nice to see you.
So, Audrey, you've been involved with Quakers quite a long time. You're an equality lawyer. Tell me about your experience of Quakers. How long have you been involved? And
Actually, not as long as a lot of people in Quakerism. I was first interested in Quakerism back at the time of the Iraq War, early 2000s, and um, I was sort of, I suppose, spiritually interested in exploring some of the issues around um, um, peace and sort of the anti-war issues in a sort of slightly left field way, in the sense of, I wasn't so attracted to the sort of anti-war demonstrations that are sort of orchestrated by the socialist worker movements and stuff like that. I was much more interested in the idea of peace being a lot more complex and taking a lot more steps. And you wouldn't start at this point, you'd start a long way back. And I was quite interested in that, and started exploring um, or started sort of questioning a sort of spiritual sense that I'd had. I was a churchgoer as a teenager, a young girl and a teenager, unlike my parents who were um atheist or agnostic or something, not really church people. But I'd gone to church, and I associated it most with singing, actually, because I was in the church choir and that sort of thing. I was rather alienated by the sort of Anglican ritual and the sort of sense of it being a one-time thing on Sunday, and then you go to Monday and people behave as normally as they do, and then back to Sunday and it becoming slightly odd. And that felt to me somewhat artificial. So in some ways, I was attracted to Quakerism as a lifestyle, in the sort of sense of sort of exploring how I could live my life in a way that meant that there was a spiritual dimension. And Quakerism sort of fitted the bill. Um, it my practice of being a Quaker, in the sense of going to meeting, and I joined a very lovely meeting in Suffolk, um, was strengthened by my son being at the time a toddler, and then as he grew up, and I essentially became a Quaker parent, in that we would then go and play with the children and sort of do activities. And I really enjoyed that.
Mm.
And that sort of set the identity, which meant that when he left to go to university, sorry, before that, he sort of drifted away from it, but definitely by the time of university, um, my sense of how I was a Quaker was slightly more problematic, in that
Mm.
the thing I really struggle with, and I know we've spoken about it when we've met, is that the thing I find hardest is meeting, is the practice of silence.
Yeah.
I feel like I'm the worst person at it. Um, just I don't have the sort of personality that stops thinking constantly, and therefore I have constant sense of feeling of being a bad Quaker, because I'm just not sort of having this sort of sense of having this sort of collective silence. Mentally, my head's like all over the place. It doesn't help. I'm partially deaf, but I also have very bad tinnitus, so I never have silence ever.
Mm.
So in practice, I've got this sort of constant ringing in my head, and a constant thinking, and then a constant, gosh, Audrey, you're not doing a very good job as a Quaker. And that's sort of, so I've got a very weird relationship with Quakerism. I like the idea of living your faith. I like the idea of there being no set dogma. I like the principles of equality, simplicity, and peace. Those things I
Mhm.
really, really warm to. It's just the practice of being a
Well,
Quaker.
we're all practicing and we're always practicing,
Absolutely.
you know.
Yeah.
Of course, this way of life that you're talking about, I mean, it's really fed into your work then as an equality lawyer, and you've specialized in the Equality Act, I think.
Oh,
Do you want to tell us a bit about how that came about and where you are now?
yeah. I didn't start off doing specialist equality law. I didn't start doing that until about 2006, and I've been a lawyer for about 30 odd years. Uh, it was really about actually leaving private practice and local government where I've been a lawyer and actually going into the to charity work. And this was long before Quakerism. When I back in the sort of late 1990s, I had a reoccurrence of some mental health problems that I'd had as a teenager, and in my 20s. Stopped work for a little while and then thought, I really can't work as a solicitor anymore. What am I going to do? And I ended up, after having the blank piece of paper with what am I going to do for a living, I ended up as the assistant manager of a disability advice bureau in Ipswich and started doing social security appeals.
Mm.
Ended up doing that for a while, then went to National Mind as a lawyer. So I ended up back in law, but very much advocating, providing legal advice to mental health advocates around the country. Uh, had my son and then came back to Suffolk, went into a different disability charity part-time. Um, and somebody, as I was doing that job, said, there's a job doing equality casework um, at the local Race Equality Council, and they're looking for somebody, and they might take you term, sort of child-friendly hours, those sorts of things. And I thought, why not? I'd done a bit of employment law, employment tribunals, done a little bit of disability discrimination, but basically just had to learn it from scratch for an interview. Went for the interview, got the job, and that was 2006. And fairly quickly I set up essentially a practice doing discrimination law. We were funded by the Equality and Human Rights Commission, and that started my journey as a discrimination lawyer, so working pro bono, free of charge, based on grants that we got first from this Equality and Human Rights Commission. Then we got some lottery funding, and basically helping anybody who was the victim of discrimination from 2012 to 2018, alongside doing my job as an equality lawyer. I also saw the need for a law centre in Suffolk to do more work than just discrimination. So we didn't have any housing legal aid lawyers or any other, very little legal aid in Suffolk. So I campaigned from 2012 and I led the campaign, and we launched Suffolk Law Centre in 2018. So alongside being an equality lawyer from then to my retirement, which was about 6 months ago, I basically did those two jobs,
Mm.
which was very satisfying. It was, very nice. I ended up getting an MBE for it, which was great. And all through that, I have really strongly felt that my Quaker faith has been a huge part of my sense of access to justice, around equality, around practical Christianity. I really got that sense of it. Um, Became more problematic in the late 2018s or so as an equality lawyer and running a charity, simply because I started seeing misinformation about equality law coming out of various parts, and felt a calling, I mean, it's quite weird because I do think there is again a spiritual element about trying to correct misinformation. So I've done, over the last few years, I've been quite active on social media, trying to play a straight bat and saying, this is what equality law says, this is what you've got to do, which has brought me into some opposition with essentially activists who have chosen to misrepresent what the equality law says to advocate for their particular cause.
Yeah, yeah. So you've got this, long background then in not just, well, all types of equality and discrimination. You
Yeah.
mentioned disability discrimination and race discrimination,
Or I've
all
I've done
sorts.
cases on all nine protected
Yeah.
characteristics.
Right, right. So, the reason I wanted to talk to you then in this series that I'm doing is thinking about how Quakers interpret this and how we welcome all sorts of people
Yeah.
across all different types of characteristics. Because I find the Quakers sometimes are over focused on some and really just leave others.
Yeah.
So I wonder whether you've got any thoughts on this, thinking about your subject knowledge and apply it to Quakers in Britain today. What do we have to learn? What are we getting wrong about the equality law? What are we doing right?
Okay, I think I would say the thing you that they get mostly wrong is the way in which they focus in on individual protected characteristics rather than thinking about equality as a single concept. Equality law, I often liken it, whether it's a good metaphor or not, to an ecosystem where if you make changes here, it can have effects there. And sometimes they can be adverse effects. So you can't think of something in the context of a single protected characteristics rights, generally speaking. If only because, for example, positive discrimination is largely unlawful, with the exception of some very disability discrimination is the primary exception, but in equality law, there's a whole load of exceptions. So in practice, you also have to take account of the fact that it's in certain circumstances you may have to do something differently, which is a form of lawful discrimination against one group because an exception allows it to prevent indirect discrimination against another group. And so the equality law, there is this the thing that most people get wrong is that they do the soundbite headline and they forget the detail, or they don't know the detail, and they don't know what the exceptions say, and they don't take them seriously. So you end up in a situation where you get an awful lot of inadvertent indirect discrimination. um, um, I think the second thing is that there is a sense of goodies and baddies, that
Mm.
these are the good guys and these are the bad guys. And equality law doesn't work like that. Equality law is a universal. Everybody can be potentially the victim of unlawful discrimination. We've all got at least three protected characteristics. We've all got a race, we've all got an age, and we've all got a sex. Yeah.
Yeah.
And in practice, we may have others. But the other thing is also is it's not about your identity. It's about the reason the decision was made or the policy affects somebody. Okay. So in practice, it's much more of a shield than a sword, in that it protects against somebody else making a decision which is prejudicial about what they think you're like, a stereotype of you, rather than taking you and looking at you objectively and with justifiable reasons, if you see what I mean.
Mm.
So, to a certain extent, there's a sort of sense of I've got a protected characteristic and something bad's happened to me, therefore it's discrimination. And as an equality lawyer, I have to go, actually, that's not how it works. Uh, I think the next thing is about conflicts of rights. Um, Basically, there is this weird saying, which I've seen an awful lot, a meme, which is they say rights are not pie. You don't lose some of your rights if you give more rights to others. And actually, legally, that's in some contexts nonsensical, in that when you're talking about finite resources, when you're talking about a single service, a single space, a single amount of money, whatever,
Mm.
and two protected characteristics are essentially vying for them, then rights are a pie. You
Yeah.
do have to say, based on the evidence, based on the context, the least discriminatory measure, which essentially means one person will win and one person will lose. But that doesn't make one person a goodie and one person a baddie.
No.
Both of them potentially can be goodies, baddies, victims, oppressors, whatever language you use. And ultimately, somebody, you're going to have to make a policy, or the court will make a judgment or whatever, that essentially rules in favour of one side and against the other side.
Yeah.
Yeah. And conflicts of rights are quite, they're not common, but they're not uncommon in equality law and human rights law. And yet, even the idea that there might be a conflict of rights was regarded a few years ago as being problematic
Mm.
by some activists. This idea that they want to grant more rights to particular groups, and that's going to be completely consequence free, is bogus in equality law. And again, it's trying to get that to be understood in context and in evidence. I'm not saying all the time. And I think the thing is about it is context and evidence is really important. So you can't generalize about everything as being exactly the same all the time. Yeah,
Mm.
it's very, very specific to a particular activity, particular evidence, particular context, what the particular views of the situations that each party finds themselves in. Okay.
So it'd be great to look at some examples here then, because one of the things that's really bothered me in the last probably 10 years or maybe less, is this idea of no debate, that we won't talk about these things at
Yeah.
all. And I think that era is now over in Britain,
Yeah.
anyway, thankfully. So at last we can start to talk about it. So I wonder if we can think about some specific examples to get your insight into that then. I mean, one of the obvious recent thing that's happened is yearly meeting that we just had in
Yeah.
2025. We had Friends House make this statement at the beginning of every session about the toilets, for example, and how how they've interpreted the ruling and the Supreme Court ruling. What do you make of all of that as an equality liar?
It makes my heart sink because toilets seem to be the dominating conversation, and in practice, I think that's inevitable because it's a finite resource.
Well,
Is
it's where we're at quite a vulnerable place as well, isn't it? It's, I suppose, and one of the things I've heard people say is if you can't get it right there, then there's other places where it's going to be even worse. But it's an emotive subject, shall we say?
it's very much an emotive subject, and it's not the only subject. I mean, we're I think changing rooms, overnight accommodation, rape crisis services, those are the
Mm.
sort of prisons. Those are the sort of, in my view, much more emotive issues. But toilets have been the one that people have asked me about a lot recently,
Yeah.
and in some ways, you sort of have to say, who are you users? Sorry, let me start it with Quakers is a charity. It's a service provider. It's also a membership association in law. So those are the contexts in which they have to. They're also an employer. And in each of those different contexts, you have to think about who's going to use the services and what does the law say. So to a certain extent, being an employer is quite straightforward. We've got the Workplace Health, Safety and Welfare Act, which basically requires there to be separate male and female toilets and changing rooms, except when you've got completely enclosed rooms with basins inside as a suitable alternative. But essentially, and then there has to be sufficient for the approximate number of those people. So employment is to a certain extent much more straightforward. When it comes to service provision and membership association, it becomes more problematic because whilst it is lawful to provide single sex services, and it may be indirect discrimination not to, it's a matter for the service provider to determine what their individual policy. So two different service providers could come up with a different answer and potentially could justify them. Okay, which is why I said it's very much about context and evidence. So, as an equality lawyer, I would look at a space and I would look at what the existing facilities were. I would also look at equality monitoring your users in
Mm.
terms of those people who are using it as members and those people who are using it because they're going to the coffee shop or the bookshop or whatever. Yeah.
Yeah.
Um, and you'd look at how many of them are elderly, how many of them are disabled, how many of them are um, um, uh, female, how many of them are male, how many of them fall within the Section 7 definition of gender reassignment, etc. And you'd also look at, I think it would be legitimate to look at the fact that quite a number of young people who are in Quakers, for example, maybe gender non-conforming, not in the way that say I'm gender non-conforming, but actually wishing to use services in a way that's inconsistent with their sex. Yeah.
Right.
So you've got a number of factors,
Mm.
and you then have to come up with a solution which fits or as much as you're able to, subject to how much money you've got, how much changes you can make, what your plans are going to be in the future, all of those sorts of things, a justifiable decision. Because what you have to do is to have in your head who is going to take me to court theoretically. Yeah. And it could be a number of different groups. It could be females who want single sex toilets.
Mm.
It could be disabled people or older people who happen to be disabled who don't think there's enough accessible accommodation. It could be um, people who claim who come within the Section 7 definition of gender reassignment who um, um, want some kind of sex non-specific toilet. I mean, unisex, multi-sex, whatever you would call it, toilet. Yeah. So you've got a range of different competing rights, all of whom could theoretically sue you for indirect discrimination. Now, just let me could just take a pause and just explain what indirect discrimination is. Indirect discrimination is a situation where a policy or the way your organization does stuff has a particular disadvantage to a group, even a small group,
Right.
which can't be objectively justified. Sorry, also the particular disadvantage linked to their protected characteristic
Yeah.
that can't be objectively justified. Yeah. So in practice, you might get a situation where the inability to get to an accessible toilet quickly may be a problem for an older person or a disabled person.
Mm.
Yeah. It may be a situation where a a female who wants a single sex space um, for privacy, etc., can't get to a single sex space. And it's not just about is there one somewhere. It's also within the context of how you work,
Yeah.
is it reasonably accessible in the sense of, if there is a 15-minute me gap in the sessions, is somebody able to go to the toilet within the 15 minutes, come back and go to the next session, for example?
Yeah.
So you could look at all of those factors. So the process that I would have anticipated, and I don't know anything about, to be frank, about the toilets at Quaker yearly meetings. So I'm saying all of this theoretically. Presumably, they will have sat down with very good equality monitoring, the demographics. Um, they would have started, in my view, with accessible toilets for disabled people, because the duty to do reasonable adjustments is a positive duty and it's an anticipatory duty. And I would start with accessible toilets, particularly also given the demographic of older Quakers. The chances are you've got a very high number of disabled people within your demographic. So I would have the starting point being accessible toilets for disabled people as being my principal concern.
Mm. Mm.
And then I would work from there to try and allocate an assortment of different arrangements of toilets
Mm.
and and then I would document all of that as being my thinking. The reason why I say that is that what I know as an equality lawyer is that if it got to court, an organization that's got a reasoned justification which makes sense is more likely to get a judge to agree that it's defendable than if it's not documented, if it's not reasoned, the explanations, the balance of rights hasn't been explored. So the first point is you need to accept that all of these groups have got rights. And I think that's quite inherent because I think there's a strain within Friends Meeting House that thinks, for example, those women who want single sex spaces are just doing it because they're difficult, bigoted, whatever. And I think that if that was actually reflected in the evidence, they would really struggle in a claim, if you see what I mean. So if there's a perception that they're doing it because they're bigoted, that wouldn't necessarily help the defense of the case. So I think you have to accept all of those groups have got competing rights and then just try and balance out the rights in a way. I don't think the courts are going to seek to impose their own view
Right. Okay.
on it. It's going to be very much about, is it a proportionate response to a legitimate aim? But I think, as with a lot of this sort of law, you're looking at a spectrum of what's okay rather than a single answer.
Because there's been a lot of court cases recently, hasn't there? It seems to me that
Yeah.
we're becoming more legally clear. I don't know if that's true or not, but my impression is that we're really looking at this in the UK. There's a lot of legal eyes on it.
In some ways, it's been a huge failure. Um, and the huge failure has been around misinformation. And I fell into the discussion, the conflict between transgender activists and those people who are known as gender critical feminists. I fell into this issue by accident when I came across on social media a policy by a charity, a youth charity, which was explaining to schools
Mm.
how they accommodated trans people. And essentially, the message was you essentially just allow them to use the facilities that they want to use,
Right.
which my instant response was, that's really legally problematic because you've got a bunch of other people, whether they're Muslim children or children who've been the victims of, sexual abuse or practicing Orthodox or some races, so gypsy women, gypsy females who wouldn't be prepared to be in a change, as for a sports changing room, undressing with somebody of the opposite sex. So you've got a number of other children within the school who have got competing rights.
Yeah.
And how are you balancing the rights? And what's happened over certainly between about 2015 and 2022, I would say, is that there was a huge amount of activism, which was openly and I think quite cynically misrepresenting what current equality law was saying.
Mm.
And that's ended up people being discriminated against and harassed quite extensively. So losing their jobs, colleagues making harassing statements against them, losing opportunities, all kinds of things
Mm.
in consequence of a legal view which was incorrect. And to a certain extent, I particularly feel very strongly about the big advocacy groups like Stonewall and some of the other trans advocate groups because they were essentially putting forward legal advice. And then when you started getting the court cases, they all said, oh, it wasn't legal advice. You know, you should have got your own legal advice. And a lot of organizations became, it came a cropper because essentially you had this incorrect version of the law being presented, um, which I think was actually really unhelpful to the trans community. There's nothing worse than a situation where you're given a sense that you've got entitlements that there was no legal basis for,
Mhm.
that essentially, there was assumptions about what equality law said. So I'd got together with a group of other lawyers who were all specialist mainstream equality lawyers, and we were like, this is really problematic, and
Mm.
it's problematic for the whole community, whether it's you know, whether it's gender critical feminists or Orthodox Jewish women or rape survivors or trans people, the law needs to be understood as it's written. And we've ended up in a situation where we had quite a number of cases disproportionately successful. I mean, one of the things you have to understand is that most discrimination cases are unsuccessful.
Right.
The statistics are quite stark that to be fair, they're slightly, when people talk about like 5% of race cases are successful in tribunal, it's a bit misleading in the sense of good cases tend to settle before they go to court.
Yeah.
So as a result, you've taken out a lot of good cases by settlements. But even so, when you're looking at 70-80% of cases with regard to the sex gender dispute resulting in judgments on one side,
Yeah.
you
Well,
know that there's been a widespread misrepresentation of the law.
yes, and that doesn't surprise me. It feels to me like 70-80%. I didn't know it was that figure, but it feels to me like there's some clarity really as a result of this. And I suppose Quakers in Britain and the trustees must have been taking some of this uh, legal advice
Oh,
from Stonewall.
there are unfortunately lawyers who are not mainstream equality lawyers. I mean, Jolyon Morm, who's talked about a lot, is a tax
Mhm.
lawyer. And yet people are taking advice with regard to equality law when mainstream equality lawyers are saying, hang on, that's not right. And I think that's been, and to a certain extent, um, I mean, some of the recent stuff as a result of the Four Women Scotland case this year has been frankly bonkers because we've got a situation where the Supreme Court, which is our alpha court,
Yes.
gave a very detailed judgment incorporating essentially very mainstream approach to a conflict of rights situation, where essentially they were looking at statutory interpretation of what the Equality Act was by looking at previous legislation, because Equality Act is largely a consolidation process of a lot of previous legislation
Mhm.
from the 70s, 80s, and 90s and 2000s. It basically got pushed into one law with slight amendments, but not in this context. So you end up in a situation where um, they were looking at statutory interpretation, something that had not happened before with regard to the concept of sex. And that's quite important. It was very much around sex, the definition of woman and man within the Equality Act.
Mm.
Um, and they've come up with this detailed determination, looking at different ways that it could be interpreted, and also how the Gender Recognition Act would be interpreted. Because we had the Gender Recognition Act in 2004, and again, there was a lot of misrepresentation about the Gender Recognition Act because the Gender Recognition Act, which only applies to a small proportion of of those people who are transgender,
Mm.
because there's only a few thousand. I think it's about 8,000 gender recognition certificates across the country. So it's only a handful of those people who are transgender. Um, will have got a gender recognition certificate. And the gender recognition certificate is very badly worded as a piece of legislation. It's very poorly written. But what you've got is a situation where they say, and I'm paraphrasing, you get a Gender Recognition Act, and then for all purposes, you change sex. But then that's in section 9.1. But in section 9.3, it then says essentially that that's subject to exceptions in this act or in any other act. And so in practice, right from the beginning, the Gender Recognition Act wasn't you've changed your sex for all purposes. It's changed your sex for some purposes,
Right.
except where it says, and the thing about it is those exceptions are has essentially been determined as being either explicit or where it's clear from the wording of the other act that it would be inconsistent to apply the Gender Recognition Act to it. And ultimately, the Supreme Court decided that because of the way that a number of groups would be affected if sex had been changed by the Gender Recognition for the purposes of the Equality Act, it can't have been the intention of Parliament to do it, and that's essentially how we interpret the Act. Now, there's been some opposition to that, and the opposition is very weird because it's a sort of a mixture of they didn't take into account human rights law, which is not true because they don't get that the Equality Act is essentially how the UK interprets the European Convention of Human Rights in the context of certain aspects. So by
That,
even looking at the Equality Act, they've taken human rights law into account. Some of them are saying, oh, but the statutory guidance isn't right. And we're like, actually, but it's the Act of Parliament that's important as defined by the Supreme Court. What the interpretation of the Act is, to be frank. And the irony being is that the Code of Practice that's actually in existence at the moment, it's currently being consulted on, has been wrong for years and years and years. And mainstream equality lawyers take very little regard to it because it's been wrong for years and years and years. So the idea that it's some kind of uh, religious text is weird. And then some people are saying we're going to challenge it. Now, somehow and procedurally, it's going to be very complicated. Somebody at some time in the future, and it would be probably at least 5 years, could get a case on this issue to the European Court of Human Rights. But there are massive number of obstacles in the way. So just because you say you're going to do it doesn't mean you'll end
yeah.
up being able to be successful.
I suppose the argument is though, is that if you can say it's contested or it's being challenged,
Yeah.
that is,
People, the point about it is saying it's contested is not the same thing as actually having a court case, a court hearing date at
no.
some court in the future with a case that's actually applicable that will rule on this issue. And the thing is about it, previously, all the previous cases, as I understand it, that have looked at gender recognition and the rights of trans people haven't looked at how you manage the conflict between them and the rights of biological females before. And there's absolutely no way that the new grassroots biological female activists are going to not intervene
Mm.
and have their say in court. So the idea that all it's going to take is for us to go to Europe and we'll solve the whatever problem. I mean, there is another way of them doing it. They could try and get a new act through Parliament,
Well,
but there is no
indeed.
political appetite for that.
Well,
And
but
the problem is they've also then got to deal with the conflicts.
yes, and I think that's would be my thought is that if there's a certain bunch of the population that actually want a new law, then that's the campaign that needs to be run rather than
Absolutely. And
making the law
I
how you want it to be.
to a certain extent, I feel as a practicing equality lawyer, you just practice with the act that's in front of you. So, I feel obviously I've got views, but I can detach those views as a lawyer and
Yeah.
say, if the law changes, I just deal with the law as the law changes. And so, to a certain extent, it's a matter of, but what the difficulty they've got is that issues around changing rooms and, should a biological female, as in the Sandy Peggy case, should a biological female who's having a period have to change clothes in the same room as somebody who is trans identified of the opposite sex? Would they have to do it? Oh, and Sandy Peggy being having previously been a survivor of sexual abuse,
Mm.
ironically by a doctor, which is quite a horrific thought as well. But so you've ended up in this situation. Now it's complicated by the fact that a whole bunch of stuff regarding Sandy Peggy's characters come up. So no doubt people will just say, "Oh, Sandy Peggy's a bigot" or whatever. But regardless, the
Regard.
whole issue around conflicts of rights. So you've ended up in a situation where we've just seen a case settle after 3 years in Sussex, where a women's rape crisis centre, which offered group therapy, only had trans inclusive group therapy, and a woman, because of her manifestation of her trauma about her abuse, felt that she couldn't go to group therapy and get something out of group therapy in the presence of somebody she perceived as a biological male.
Mm.
And we've now ended up 3 years later, after considerable amount of litigation, and there was going to be a hearing in September, with a settlement whereby the charity has now agreed to providing an additional service for biological females only.
Mm.
Now, that should have, in my view, having her having raised her concerns 3, 4 years ago, should have been sorted out 3, 4 years ago with this, with the provision or some kind of fundraising effort or something to provide that service. But because the charity was adamant that all their services had to be trans inclusive,
Mm.
and that this concept of inclusion, it becomes weaponized,
Mm.
point
Mm.
where you're happy to exclude others in the
Oh,
name of
indeed.
inclusion of certain specified groups. You end up in a situation where a very vulnerable person is unable to access an additional service for people who think like them. And I think one of the things that I would say that Quakers are very bad at is welcoming gender critical
Mm.
people. I think they're very unwelcoming to gender, and not particularly my meeting,
No.
but generally as a corporately, and a lot of the stuff that's talked about, there's a sort of sense of you're bad people, you're bigoted, you shouldn't have any kind of say, you don't believe other people should exist. There's no real listening to what actually their concerns are. There's
Mm.
no listening to, there's an assumption, there's a sort of amorphous mass. So apparently everybody who is gender critical, or whatever the expression is, must be like the worst person
Mm.
in that section, rather than necessarily understanding that there's probably gradations of thinking.
Mm.
But regardless, particularly given the fact that gender critical beliefs are protected philosophy,
Mm. Well,
legally, Quakerism cannot discriminate unlawfully against gender critical people. And
mm.
yet that acceptance of the law, I've never seen.
No,
And
it's
that's
very
really
interesting. And
interesting.
and one of the things you just mentioned about the Peggy case is that, even if we're talking about people who have, tasteless opinions, or perhaps are offensive people, even if we're talking about, as
Oh,
we talked about,
yeah.
criminals anyway, people who have done awful things, they still have rights.
Oh,
Um,
it's really interesting, actually. Yeah, I mean, it's back to this sort of sense of goodies and baddies. The
mm,
problem, the problem for them is that the Equality Act is universal.
yes.
And I constantly would say, I mean, I mean, you sort of adopt some gallows humor with regard to some clients. Some of my our clients were awful, but all people have equality rights,
Yeah.
you know.
And and in
And
a Quaker,
interestingly enough, about bigotry, my biggest bigotry is clients who wouldn't cooperate. So, you know, attend meetings or give you the information you require and all those sorts of. I used to get very mentally very short with them, and I had to check myself. So, everybody's got lines of bigotry which don't necessarily line up with your traditional lines of, you know what I mean? So I,
yeah,
I
yeah.
struggle with people who are late to things and things like that. And, ultimately, we all of us are human beings.
Mm,
But it's interesting how we've become a society now which is very, very tribal,
yeah.
and Quakerism is infected by that tribalism. There's this sort of the goodies, the baddies, the virtuous and the wicked. It
Mm,
really is very binary, interestingly enough. And in practice, I look at people who believe some of the things I believe, and some of their other beliefs are horrendous to me. I look at some people who have got opposing views on some issues, and other issues I'm completely on board with. This idea that you can divide the world into good and bad is very
mm,
problematic to me instinctively, as well as being a Quaker. And yet, when it comes to this gender trans issue, it becomes weirdly binary, and that there's no sense of nuance or degree, or, you know what I mean? You have to accept a worldview which says that not only do you have to accept that trans people exist, I don't have a problem with that, but you also have to accept everything that they say as being gospel correct,
mm,
which I have a problem with. You have to accept that there's no conflict of rights and there should be no debate, both of which I've got a problem with. And you go on from there. And so I'm like, of course I accept. I've acted for trans people in discrimination cases where they have been discriminated against. I believe they exist. I endorse their right to exist. That doesn't mean necessarily I think that they should be able to share a female changing room in the
yeah,
context where there will be women who disagree with that,
yeah.
or have problems because of their own protected characteristics. And this idea that somehow because you accept the existence also means that they should get everything they demand, to me
That's
as an
right.
equality lawyer, doesn't make any sense,
No, that's right.
to the point of
And
it actually being disingenuous.
mm. And I suppose personally, I mean, I get called bigot and transphobic and all of that. I mean, I think sex realism is perhaps the best phrase, but gender critical is what
it,
people are
it's
called. But I don't mind. But the
yeah.
fact is, I believe in the reality of sex, and I suppose my view is, well, I don't care if some random Quaker thinks that I'm a bigot or thinks that I'm a baddie. It's like. Their opinion of me doesn't really matter to me. I mean, to me, this is why, we trust in an all-powerful God. Like it's
I
God's judgment of me that I care about, And
Yes, but I mean, uh, there were times when people complaining about my lawful interpretation had real life adverse consequences. So, and it was very problematic for a few years. Not so bad now, but very problematic for a few years. So this idea that, it doesn't cause you any difficulties, it has caused some people
oh, I'm not,
huge
yeah.
difficulties.
I'm saying their emotional attack of me doesn't
Yeah,
bother me. I
I
mean,
get that. But
if I mean, obviously, I trust that God will protect me. I mean, that I just have a spiritual angle on it, really, and I try to be as truthful as I can be. And I also believe the truth is kind. The
yeah,
truth is actually kinder
yeah.
than some kind of superficial compassionate stance of just going along with what people want to be true. I think, well, actually, truth is the kindest thing often.
But
And you can say
also,
it gently.
there may be a number of different truths, and all of them can be okay. Ultimately, it can come down to people having different worldviews, and that's fine. Where I have a problem with it is when it's used as a justification for our unlawful conduct,
Yeah.
which is what we've seen over the last few years. And the failure by Quakers to recognize that unlawful conduct, not necessarily by themselves, but by the Open University or Sussex University or Edinburgh University or Cambridgeshire County Council or CGD Europe, the organisation that discriminated against Maya Forstater, or five NHS trusts. So you go on and on and on. The point is about it is that the fact that Quakers essentially, by taking sides, have essentially closed their eyes to unlawfulness and active unlawful discrimination and harassment of people with lawful beliefs is a real problem to me as a Quaker. That essentially it's in some ways they've said nothing to do with us.
Mm,
We're good, we're kind, and by that sort of we're not seeing the unlawful discrimination done against Dr. Joe Phoenix or against Maya Forstater or all of the other people who have been discriminated against. That failure to actually engage with what's going on
mm,
because of um, um, a um, the manifestation of the way that the belief is happening in the real world is very problematic to me. I mean, you know what I mean? It's like, it's fingers in the ears and shouting la 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 again
yeah, yeah.
in a way that's participating in unlawful conduct.
But you know, when we think about the people who are being mistreated, if you like, and forgotten about, I
And
think, in a way, kind of the sex realist Quakers are not as much of a concern for me in how they're mistreated as people such as detransitioners. Um,
oh,
one of
but
the things that
it's
I
not.
have a
It's practicing Orthodox Jewish women who can't swim in a ladies' pond in Hampstead. It's the victims of sexual abuse in Sussex. It's nurses working in the NHS who just want a changing room to change their bloody scrubs.
yeah.
And you go on from there. The reality of the situation is it's not about internally about you know, uh, uh, generally speaking, it has to be said that the demographics of Quakers is relatively privileged, all of them. We might all have mental health problems or other issues, but on the whole, compared to, for example, some of my Gypsy and Trava clients or my Romanian Roma clients or clients, adults with learning disabilities or um, women who are giving birth who don't speak English,
Mm,
sort of real issues where they're not even in the room to have the
mm,
conversation.
mm,
And this idea that, um, that to be frank, anybody who's got a platform is relatively privileged, and we need to accept all of us in Quakers are relatively privileged. But the impact of our actions are felt amongst people who are never listened to, um, who got no access to, who don't get featured in Vogue or who don't, haven't got social media platforms. They're people, basically ordinary people in working life, and they're sometimes bigoted, they're sometimes problematic, they're sometimes disorganized. They certainly a lot of them have difficulties bringing legal cases. They don't have whole NGOs working for them. It's a very different set of things. But, the very fact that I know that traditional English gypsy women generally want to lead want physical privacy or went away from males, and though therefore would be condemned by Quakers as transphobic.
Absolutely.
And
Yeah.
then there are also gypsy trans people. So I'm not saying that no gypsy people are, and even the fact that I know that some gypsies want to be called gypsies rather than, suggests I've been in rooms and talked to people who don't have the head office concepts,
Yeah. Yeah. Well,
and they
exactly.
don't
And
have the same
I
language.
spend a lot of time with what you might call ordinary people, who are not in the Quaker bubble, if you like.
Yeah.
And it does worry me. And I suppose this is why detransitioners, people who are somehow caught up in that idea of being the opposite um, sex in their own minds, but then have moved away from that. Now, what
Oh,
what I'm coming across is
yeah.
people within Quakers who are in that very minority group, but
Yeah.
then of course they're not feeling very welcome in the Quaker culture because we've become so dominated by this pro-trans perspective. And
Oh,
that's real heartbreaking to me, really heartbreaking.
but I think part of the issue, and I think to a certain extent, it's a wider problem, is groupthink, is the idea that you have to think we've ended up in a sort of omnicause, a situation where you have to believe the same things on Israel Palestine, on climate change, on Brexit, on um, gender, whatever, sex, trans issues. You have to have, and heaven forbid that you're part of the LGBTQI community and being a sex realist, that, or a trans detransitioner, or a trans widow, or a child of a trans person who doesn't actually want their parent to be trans, or anything which sort of goes against this sort of. And ironically, I think it's the group think that I've really struggled with Quakers, because I'm I'm very undogmatic, and therefore my whole world is in the world of, it's all got to do with context and evidence. So when I say, I have more sympathy sometimes with the sex realist approach, I don't think that all the time. In some contexts, I think it's wrong. In some circumstances, why can't we have mixed? I struggle with some things, and doesn't necessarily I'm right. I mean, one of the lovely things is, think it possible you might be mistaken should apply all the time to every sentence you ever think. And examining, and the answer is you come up with is so messy, but the world is so messy. And the lovely thing about equality law is it embraces that messiness
Mm, mm,
wholeheartedly. Interestingly enough, I think that's one of its superpowers,
yeah,
is that it has a combination of discrete categories in some senses, so that you don't end up with a situation of complete mishmash. So the protected characteristics are defined. Yeah.
yeah,
But then you have a situation where indirect discrimination allows for context and evidence, so that give you an example. Have you heard of the Awader case, which was about a Christian woman who worked for British Airways who wanted to
oh,
wear a big old cross around her neck?
yes,
Yeah.
yes,
She went all the way to the European Court of Human Rights and won against British Airways to wear this big old cross. Same case, same hearing. There was a case called Chaplin, who was a nurse who wanted to wear a big old cross around her neck. And the European Court said, no, the context you work in, it wasn't unreasonable to refuse you the right to wear a big old cross around your neck. And so you've got two cases about essentially the same issue in very different contexts, and the outcome was different. And that, in my view, is the strength of the Equality Act rather than a weakness,
Mm,
because it accepts the messiness or the different situations that in different places. So when somebody says sex matters, they don't mean it matters all the time. They just mean it matters sometimes.
yeah. Yes.
In those contexts, sex is important, but in other contexts, it's not.
Yeah, indeed. And what I'm hearing you saying is that whereas the Equality Act is allowing for this complexity, Quakers have somehow oversimplified it down, and we've ended up with a groupthink situation which is almost creedal. It almost
Yeah.
feels
Yeah.
like for a non-creedal church, which is what we all have joined perhaps
Yeah.
because of, we've ended up with this unofficial creed that if you don't believe all of these things, you're somehow not quite a part of it, which I just think is a very peculiar situation we've got to in Britain.
I tend to agree with that. I tend to agree with that. And I think the difficulty with this idea of no debate, and I don't have a problem if it was no debate as to the existence of some people being trans. I personally also think that Section 7 of the Equality Act should remain, and we should have protection against unlawful discrimination and harassment with regard to gender reassignment, which some people don't agree with. I genuinely believe that.
Mm,
And there's a bunch of other stuff that other people who are sex realists believe that I don't really believe, and that's fine.
mm,
But when it comes to, you know, issues of um, what are you actually asking in the real world? What are you wanting in the real world? How will that impact on other people? Then there has to be a debate. There's debate about every law, and there has to be in a democracy. And by law, I'm talking about not just statute, but every rule in the way that Quakers do stuff.
mm.
There has to be discussion. There has to be
Well,
disagreement.
and discernment, of course. There has to be spaces
Ups,
in which we
yeah.
can discern
And
this. And up until now, we've really not been able to do it. We haven't, none of the central organizations that I know of are really doing it very well. There's been some examples, for example, Norwich Quakers, I think, did
yeah,
an
very
important
good
piece
job.
of work to thine own self be true as
Interesting. I went to the
project.
meeting that they
Did you?
I was actually at the meeting at which there were a wide variety of opinions. It was a very good meeting that
Norwich.
that inspired the report that you're referencing.
Right.
And I thought it was an exemplary example. I was heartened by it.
Mm,
And I was very disappointed when that approach wasn't adopted wider. You um, you the thing is about it is I don't think the problem is actually about the acceptance of trans people. I think the problem is actually now the acceptance of real sex realists. You've
mm,
actually ended up in the opposite scenario where what is the space? What is the what is the what is the welcome for sex realists? And I think that's the problem. And
mm,
the fact that they're not seeing it on the other side is because that lack of debate, they're not seeing how sex realists can be welcomed
mm.
into Quakers. And I think that that's the real shame is that the irony being that many of us are probably the most gender non-conforming amongst, you
Yeah.
know, that we've come to it in a very gender non-conforming way, but one which recognizes that in certain contexts our biological sex is really important, and everything else, to be frank, is our personality.
Mm.
And I don't think that situation is of any threat to trans people.
No, no. It's
And
very well intentioned, isn't it? I mean, I keep saying that. Quakers are doing all of this in a very well-intentioned way.
Yeah.
It's out of what they see as a compassion for the suffering of a particular group of people. And I just think sometimes these intentions can be, lead you off down a little bit of a narrow way of thinking.
But it also comes back, unfortunately, to some stereotypical thinking that, for example, anybody who comes within the definition of gender reassignment is somehow the most vulnerable person in society. When, to be frank,
They're not.
it's not factually correct that
No.
everybody who falls within that
Mm,
definition
no.
is the problem is that we've actually put, I don't think helpfully to trans people, because I think there's a sort of, ironically, it's a sort of bigotry of low expectations. We've put them in a sort of vulnerable victim situation, which actually means that, particularly amongst the younger people, it very much impacts their way of thinking and their self-confidence because they're really concerned that a lot of people are going to be very harmful to them, when in reality, I think with a bit more discussion and a bit more understanding on both sides, it would actually give particularly younger trans people a more confidence
Mm,
and the skills and tools needed to and the resilience needed to cope in a society where they're one of nine protected characteristics. And I think that's the point about it is, I mean, in some ways, my view has been very much coloured not by um, necessarily the sex gender issue, but just when I was working at Race Equality Council, I was seeing so many people of colour who had experienced historic racism, and then they would describe the situation they were currently facing and seeing it influenced by the fact that they'd grown up in a world which had they experienced genuine racism, but the issue that they were looking at wasn't because of their race. It
mm,
was for some other reason. So I was having to say to them, actually, that's not unlawful discrimination.
mm,
That redundancy or that situation where you didn't get the promotion was because you actually didn't put in a very good application or something. Objectively, I could see that.
mm,
And in one person's case, actually, it was about an interview. We discussed the interview they'd done for a particular job, and they clearly hadn't prepared for the job. And he'd said, "Oh, I've got another interview coming up for a similar job." And I'd said to him, "Well, you need to go away and research this, this, and this." A month later, I got a message to hear he got the job. And, I was so delighted. But he was convinced it was because of his colour
mm.
rather than the fact that he was just giving the wrong, he'd focused on the wrong issues,
Yeah.
particular
Well,
role. Now, I'm not saying that because that's the situation all the time, but what I'm saying is that if you've experienced discrimination and prejudice in other aspects of your, previously, then you can interpret things in a way that aren't necessarily because of unlawful discrimination. And as a discrimination lawyer, and particularly in the understanding that ultimately, if it goes to a court, a judge is going to be a lot less friendly and kind than I am. My process during that time was very gently to look for other explanations
yeah.
other than unlawful conduct. And sometimes you wouldn't be able to find them, and therefore you could say, in the absence of an alternative, it must be race discrimination or whatever. But if there is a genuine alternative explanation, sometimes I'm having to say to the client, well, in this case, you're not going to win your case, and it's going to be 3 years of quite a lot of stress, and you're going to lose.
Mm,
And unfortunately, nobody's gone through that process. Everybody keeps doing oh, you're a trans person, therefore you must be being treated badly.
yeah.
And that must be because you're a trans person. And, what you want should be what everybody accepts. And the law doesn't work like that. And it's not,
Mm,
I don't think it's particularly kind. And the worst thing is when they misrepresent what the law says,
yeah.
because in my view, that's setting people up to fail. I think it's really unhelpful to trans people.
Yeah. Yeah. And I suppose that's what I hope these videos do really is rather than just branding all of us people talking about these kinds of issues as being a problem, I think maybe there's an alternative explanation. Maybe there's a truth in what we're trying to bring to a wider discussion, really.
At the very least, thinking about how it would look in court, and particularly where there's a conflict of competing rights, taking that approach and accepting that both sides might have a point
Yes, exactly.
is a very good way then of trying to work out how to solve a practical problem where there are finite resources to be had. And in practice, as I say, if we can move away from this goody baddie binary and just recognize people as
Yeah.
people who have competing conflicts of competing rights, I think it would be a much healthier environment to be in,
Mm,
and one which is more sustainable in the longer run. Because if you say you've got to wholeheartedly sign up to this set of dogmas, and you're an organization that has not traditionally been quite very dogmatic, then that's going to alienate a lot of people who wouldn't be alienated otherwise.
mm. Well, let's hope then, Audrey. Thank you so much for talking to me. I think we've covered a lot of ground there. Let's hope we get some feedback and it makes some Quakers think about how we deal with different groups of people.
Hopefully. I mean, I I have a very interesting experience having dealt with all protected characteristics. I think that's something that I probably bring that other people who discuss these issues don't have, but also that detachment that comes from being a lawyer. And I know, and to a certain extent, I think that that sort of slight sense of the ability to step back and try and look at things in a non-emotive way,
Mm,
I
mm.
think is actually very helpful in situations like this.
Well, thank you very much, Audrey. It's been great talking to you.
Thank you so much.